combined with beatings also fall under this category. Your Honor, in our case, residents were routinely subjected to interrogations, and after that, many men were separated for secondary screening. Your Honor, what's worse is that they never returned. They disappeared without any official acknowledgement, which demonstrates that the mental harm inflicted upon the Birani population was equally enduring and profound. Moving towards...
When was the last time the International Criminal Court convicted someone for genocide?
I'm not aware of that, Your Honor.
When was the last time any international tribunal convicted anyone
I'm
for
not aware
genocide?
of that, Your Honor. I'm not aware of the recent cases. Apologies, Your Honor. The final element required to establish genocide is the deliberate infliction of conditions of life calculated to bring about the destruction. Entire towns were encircled, their utilities were cut off, and road access movement was severely restricted, and the access to food and medical care was deliberately constrained, leading to widespread deaths from untreated injuries. Your Honor, taking into account the foregoing discussion, it is evident that all four conditions under Article 6 of the Rome Statute are fully satisfied and collectively established. Both the charges of the crime substantially overlaps with that already established in relation to genocide. So in interest of time, I will not revisit those elements again, but the substantive distinction between both these charges is about the knowledge and intent requirement under both the charges. So I'll proceed with that. Your Honor, under Article 7, subsection 1 of the Rome Statute establishes that, Your Honor, can I have 2 more minutes to conclude my argument? Grateful, Your Honor. Article 7(1) of the Rome Statute establishes that crimes against humanity require knowledge or intent regarding the attack. The elements of crime further clarifies that the accused does not need to know every working of that state policy. It is sufficient that he knew that his knowledge and actions were part of and he intended to contribute to a widespread and systematic attack. This principle was demonstrated in Cordish and Shokis at paragraph 236, where the court held that for murder, it must be shown that a victim died, that the death resulted from the conduct of the accused or the subordinate, and that the accused intended the death or knew it was likely to occur. In our case, Your Honor, internal briefings and the personal documents which the prosecution has already demonstrated before this Honorable Court clearly show that Muhammad Nizam had full knowledge of the operations that were conducting in Marra. He approved the attacks, allowed them to proceed, and failed to take any action to prevent the resulting civilian deaths. I would like to draw the court's attention to paragraph 40 of the facts, which records that he actively dismissed the individual inquiries. Your Honor, despite the fact that civilians were killed repeatedly during the coordinated operations, it is clear that Nizam understood his conduct would contribute to the larger campaign of violence.
As opposed to actively committing a crime against humanity.
Sorry, Your Honor?
Perhaps he was just a negligent, incompetent leader.
Your Honor, the evidences show that he had his intent. He was continuously holding that the Biranis should be resolved conclusively. Accordingly, Your Honor, the prosecution finally submits that Muhammad Nizam, as Prime Minister of Ashkar, had effective control over both the Ashkar National Army and Ashkar Air Force, as well as the civilian administrative apparatus. His failure to exercise control and his endorsement of these destructive policies render him fully liable under Article 28 2b as a civilian superior. Therefore, he bears individual criminal responsibility for both the charges. Your Honor, having concluded submissions on both the charges, if the chamber has no question at this stage, my co-counsel will further proceed with the third charge. Grateful, Your Honor.
Mr. President, Your Honors, may it please this Honorable Chamber, My name is Arisha Ismail, counsel on behalf of the prosecution, and over the course of next 8 minutes, I will address count 2 of the indictment, enforced displacement as a crime against humanity committed between February and September 2024 against the Birani civilian population. For this issue, the prosecution will advance the following 3 sub-submissions. Firstly, unlawful and forcible displacement of Birani civilians. Secondly, discriminatory attack against state policy, and lastly, civilian superior responsibility of Muhammad Nizam under Article 28B of Rome Statute. I would request the Honorable Bench to bring their attention towards page number 21 for the memorial of prosecution. If the Honorable Bench has had their attention, may the Council proceed. Much obliged, Your Honor. Your Honor, the forced displacement of approximately 480,000 Birani civilians from Marra province constitute enforced displacement or forcible transfer, which is a crime against humanity under Article 7, subsection 1D of Rome Statute. The Biranis were lawfully residing in their ancestral towns of Lidhar, Guzra, and Pedhak, as mentioned in fact number 55 and 56 of the Moot problem. If Your Honors could review that for reference. Much obliged, Your Honor. And it has also been held by the International Criminal Court for former Yugoslavia in Prosecutor versus Bosco Nataganda, judgment para number 1069, that lawful presence does not require formal title. Habitual civilian residence suffices, and therefore Birani civilians were residing in their ancestral homes. This protection has also further been reinforced by Article 50, subsection 1 of Additional Protocol 1 to Geneva Conventions 1949. Furthermore, the displacement was forcible in both law and fact. Civilians were only given 30 minutes at a rural area of Marra in the early hours of morning to evacuate, which were accompanied by threats of detention, while their homes were marked as security risks, their homelands where they were residing. As mentioned in fact number 55 of the case, if Your Honors could review that for reference. Any resistance was further met with intimidation, arrest, or destruction of property, and over 320 villages were destroyed in their entirety, preventing their return effectively, as mentioned in fact number 56 of the case. The ICC in Prosecutor versus Milomir Stakic, para 281 of the International Criminal Tribunal for former Yugoslavia, have consistently held that displacement is forcible where coercion or fear eliminates any other genuine choice to appear or apparent consent under fear. Your Honor, if Your Honors does not have any further question, may the Council proceed towards the next submission. Much obliged, Your Honor. I would request the Honorable Chamber's permission, attention on memorial page number 24, mid-portion. Your Honor, there was discriminatory forced displacement as a part of a widespread and systematic attack and state policy. The forced displacement of Birani civilians was discriminatory in nature and carried out pursuant to an official state policy forming part of a widespread and systematic attack directed against a civilian population, thereby satisfying the Shapiro requirement of Article 7.1 of the Rome Statute. The scale and intensity and organization of the displacement itself demonstrates its widespread and systematic character, as nearly 1/3 of Marra's population was affected as mentioned in fact number 56 of the case. Through coordinated military operations, namely Saffron Tide, Iron Harvest, and Eastern Resolve, which has further been explicitly stated in fact number 38. This was not a series of isolated excesses, but a planned and policy-driven attack, and which followed a particular course of conduct, which is also confirmed by this Honorable Chamber in Prosecutor versus Konaraj, paras 415 and 416, that an attack under Article 7 constitutes and encompasses any course of conduct involving multiple attacks against civilians, even outside active hostilities, whereas in the present case, there were explicit active hostilities. This has further been reinforced by SZABIST, an honorable jurist of this Honorable Chamber, who further explains in his academic writings that crimes against humanity are defined by the contextual attacks. And here, those contextual attacks being the 3 widespread campaigns launched at the Birani population, as mentioned in page number 23 of the case. Within this broader attack, the displacement was distinctly discriminatory. The measures were disproportionate, targeting Biryani civilians in their entirety, who were collectively designated as security risks. Fact number 55, which explicitly demonstrates that their political identity and their ethnicity became a problem. Internally, the government classified 70,000 Biryani individuals as persons of interest, which demonstrates that those people were persons of interest, and there was no other any other issues that the government had with them. No comparable measures were imposed on the Khalgari population, on the other hand, and the attacks were launched in Maras population, which constituted 70% Biryani civilians. I would request the Honorable Bench to have their attention on memorial, page number 24. Your Honor, the discriminatory intent is further corroborated by internal state directives ordering officials to empty Biryani districts in their entirety, mark civilians refusing relocation as hostile, and remove Biryani communities from Mara in their entirety, as mentioned in fact number 57 and 58. These directives confirm that the displacement was not incidental, but a deliberate policy aimed at altering the province's demographic composition. I would now request the Honorable Chamber to allow me permission to proceed towards my last submission. Much obliged, Your Honor.
I have one question before that. So you brought 3 charges against Prime Minister Mohammad Nizam. Is there a precedent in international criminal law whereby one person has been convicted by an international tribunal of 3 charges under the Rome Statute?
Much obliged, Your Honor. Your concern is valid. Not just one precedent, but there are 3 precedents for that. If you could have your attention on memorial, page number 25, for the prosecution in Prosecutor versus Delalic, International Criminal Tribunal for former Yugoslavia's case, trial judgment para number 378, which explicitly states that that an authoritarian, that a person who is exercising effective control and commands material ability to repress or suppress crimes and establishes inaction in that situation is criminally liable for such acts, imposing the direct liability on Mohammad Nizam.
Mohammad Nizam. How many charges? How many offences under international criminal law, as it then was at the time of the special tribunal?
If you could please repeat your question, Your
In
Honor.
the case that you're highlighting, you highlighted 3 cases in response to my question.
Yes,
that
Your Honor.
there have been instances in international criminal law where certain persons have been convicted or charged by an international criminal tribunal for several offences. So what are the offences involved in those cases?
Your Honor, thank you for your concern. However, there are not several offences. There is just one single offence, that where you are in authority and you exercise effective control over your population.
That is not an offence. That is how you attribute the offence. That is the mechanism that you can have 2 extra minutes.
Your
but that is
Honor?
the mechanism that international criminal law provides to attribute liability.
Much
that is
obliged,
different.
Your Honor.
But you brought 3 charges: genocide, crime against humanity, and what's the third one?
Crimes against humanity and the civilian superior responsibility on Mohammad Nizam.
Yes. So genocide and crimes against humanity.
Much obliged, Your Honor. But we are present at the confirmation of charges stage of this in Honorable Chamber, and therefore
that is precisely why this question is relevant. Perhaps
Exactly,
this
Your
tribunal
Honor.
may or may not confirm both charges that the prosecution seeks to press.
Much obliged, Your Honor. That is exactly the reason we are attributing these crimes, and we firmly believe that Mohammad Nizam is and was cognizant of the information. If you could review fact number 57, 58, and 59. Those explicitly mention that he was receiving internal briefings from the people working under the officials, and yet he commanded proceed. Civilian members are irrelevant if area is secured, and do not delay operations, showing his complete disregard, and while being cognizant that the civilians were at stake, yet he allowed them to proceed. And they were also leaked ministerial directives. If your Honorable Chamber could bring your attention on fact number 57, then as per these informations that he was receiving, he showed a complete disregard to all these informations and continued the injustices happening towards Biryani civilian population, while Khalgari population was not being attacked at all.
What about the military leadership? The people that are actually executing these instructions?
Much obliged, Your Honor.
Why aren't there any charges against them?
Your concern is valid. There are charges against them. If you could bring your attention towards fact number 41 of the case, where it clearly states that Ashkar army executed midnight raids in towns of Harban, Velik, Ruda with machine guns and weapons and ammunitions and gunfire, including gunpowder and rifles.
then why isn't the prosecution so much interested in Ashkar Army's military generals?
Your Honor, the prosecution is not just interested in the army, the prosecution is interested on the criminal liability that lays upon Muhammad Nizam, and he exercised effective control. The army was under him, the state was under him, the officials were listening to his commands, and yet he did not take adequate actions and completely showed disregard towards the casualties. It amounted to around 189,760 casualties, as mentioned in fact number 37 of the case, and therefore, due to these reasons, the prosecution praised before this honorable court.
And
Before that,
what are those reasonable grounds that could have been taken by the Prime Minister at the situation?
much obliged, Your Honor. The reasonable grounds could have been taken that he should have directed that the attacks should be clearly towards militant insurgents and not the civilian populations, whereas he completely directed them to proceed regardless of the fact that the civilians were being subjected towards that. And fact 59 and 58 and 57.
Can't that be considered as a collateral damage?
Collateral, Your Honors, collateral damage to what?
Towards this particular community that you are referring to.
There was explicit collateral damage, Your Honors, because it was only the Birani population that was being subjected to these injustices, while Khalgari population also constituted a certain percentage of the area, yet there were no injustices against them. And it is explicitly mentioned in fact number 8 of the case, which states that Mara constituted 70% Birani civilians, who lost their lives and resulted in the casualties of 189,670 people. If Your Honors does not have any further questions, may the Council proceed towards my prayers.
If I may. These military operations seems to be consequent, allegedly the consequence of attacks on the military and administrative infrastructure. So where do you draw the line? How do you differentiate?
Much obliged, Your Honor. Here comes into play the wide principle of customary international law of proportionality. The counterinsurgencies that they are referring to were far small in scale. They only resulted in 15 militant, and whereas the injustices that they directed towards Birani civilians, they resulted in the loss of lives of civilians, not just militant personals. So the principle of proportionality comes into play, that if you are subjecting a certain percentage of people towards any injustice or any crime against humanity, then that should be proportionate towards what action the other state has taken, which is clearly not in the case at hand. If Your Honors is satisfied, may the Council proceed towards my prayers.
We will take a look at the prayers from your point of view. Thank you.
Much obliged, Your Honor. The Council seeks permission to leave the floor. Thank you.
May I begin? It is an honor to present this case before the Honorable Court. My name is Jia Vishnu and I am appealing as counsel on behalf of defense. I will be taking 10 minutes to cover the jurisdiction, the admissibility, and count 1 and count 2 regarding this case, and my co-counsel will cover count 3 and the superior responsibility under Article 28B. First of all, under Article 12 of the statute, the court's jurisdiction of a crime requires two things. One, that Ashkar be a state party that has ratified the Rome Statute, and B, the state itself has set out a declaration under Article 12.3 conceding to the jurisdiction and giving consent to the jurisdiction itself. Here, Ashkar is neither a state party nor has set out a declaration. If the prosecution comes here and makes a case for an ad hoc consent given based on the Article 58 summons, Article 12 completely bars that on the basis that there needs to be explicit consent, and under Article 12.2 and Article 12.3 there can only be ratification or a declaration for the ICC to be able to hear this case. Based on that, the defense invokes the provision given to it under Article 19, where it says that the defense can, at the first opportunity given to it, claim that the jurisdiction is not valid, and under this issuance, it can be final, since the summons under Article 58 is ex parte and prima facie only and is not binding in its perpetuity. Even for the sake of argument, if the jurisdiction is allowed, the defense pleads that under Article 17 of the Rome Statute, this case is inadmissible. Article 17 requires that the state party where the crimes took place is unwilling or unable to prosecute the person concerned of the crimes. Now, the onus falls on the prosecution to discharge that Ashkar A does not have the willingness and B does not have the ability to prosecute Nizam. Preempting their argument would also fail because Ashkar, as we have seen throughout the case file, does have the institutional and administrative force to carry out proceedings if it wants to. B, the prosecution would have to prove that there is a complete judicial and institutional collapse for Ashkar to be unable to go ahead with its proceedings. If the Honorable Bench has no more questions, can I proceed with count one? Count one is essentially on Article 6, which entails that following acts committed with the intent to destroy in whole or in part a national, ethnical, racial or religious group as such. Important to note here is that even though Birani do form an ethnic identity, when we apply the perpetrator perception test that was established in Aka Yesu, what matters here is how the perpetrator, that is Ashkar, or as concerned Nizam here, viewed or perceived the victims. As it was repeatedly, as we refer back to the fact file, in paragraph 37, paragraph 57, and paragraph 43, words such as persons of interest, affiliates of Hassan, and separatists were used. This is enough evidence to grant the fact that that Nizam here and the state here perceive these people as separatists and as people who are insurgents, and they're destabilizing the political state. Even though the Biranis hold a different ethnic identity, the reason why the people were targeted was because of their political affiliations and not solely based on their identity. Moreover, there is complete lack of evidence where Nizam explicitly says that the Birani need to be wiped out. Even though in the ministerial directives, there's the word Birani being used, the court should also consider that Birani can also be used interchangeably for Birani League liberation, not the Birani people themselves, and there is no explicit mention of the Birani people being targeted here. For these reasons, we submit that there are substantial grounds that do not exist for genocide, and the evidence does not fit for the crime of genocide under Article 6. If the court allows, may I proceed to count two? We do concede that displacements have occurred, but this was a lawful evacuation and not a crime. Additional Protocol 2 of Article 17 states that evacuation of the civilians is possible and is lawful if it is done as a military necessity and for the safety of the people themselves. As we have seen, the insurgents were hiding inside the Birani villages where ordinary civilians were residing as well. When the military are looming around those villages and are asking the people to evacuate, we know that it is for the safety of the civilians that they do not get held in the crossfire, and that's why they are being redirected to protection zones where their basic necessities are being met and proper family rosters and legal documentation proceedings are taking place to ensure that everything is lawful. These areas by the state at this point are considered military zones, and in the heightened tensions that was going on around at the time during these areas, evacuation was done with the purpose of safeguarding Biranis from active combat. The prosecution cannot argue that the return of the Birani people was impossible because there is no such explicit mention of it. And as we have seen, the additional protocol to Article 17 makes no mention of whether permanence of the evacuation is an important factor when
Counsel,
considering.
why are you referring to the additional protocol here?
The additional protocol to here is being read in tandem with Article 7(1)(d), which is concerned with forcible transfer. Additional protocol 2 states that if there is substantial ground to believe that the evacuation was done for the safety of the people and because it was a military necessity, then Article 7(1)(d) cannot be invoked.
And where does the additional protocol apply, in the context of which armed conflict?
In the context that the evacuations were done here, and
Does the additional protocol 2 apply to an international armed conflict or a non-international armed conflict?
it applies, I think we believe that it applies to an non-international armed conflict.
And the context of a non-international armed conflict, you would say, is essential to establish a crime against humanity, especially displacement.
Yes.
Whereas genocide doesn't require the context of an armed conflict.
Genocide here is treated as a separate count, and crimes against humanity is treated as the third count, which my co-counsel will explain.
But for this, you're saying the context of non-international armed conflict is essential.
Yes.
And how would you say that there is a non-international armed conflict?
Because first of all, the Birani League Liberation is a national party, and they operate nationally. There is no proof that they are receiving any sort of international funding or that they are receiving any sort of help from any international party. Does that, if the court has no other questions, may I proceed? Lastly, I would like to say that the defense would not quibble that the number is huge and that the scale is huge. However, the scale itself does not mean that genocide or intent to create genocide or intent for forcible transfer, evacuation or displacement of these people can occur. If we refer to paragraph 372 and 373 of the case Bosnia v. Serbia, as it has been highlighted in the excerpts, even though the scales are large where the Bosnian Muslims were killed and the Croats were killed, the court still found that the scale itself is not sufficient enough for the court to rule that genocide and intent for genocide and intent for forcible transfer can be found. Moreover, lastly, I would like to highlight that the counsel for the prosecution themselves conceded that the Birani were a collateral damage, which means that they were unintended damage here. There was no intention found here, and that there were insurgents in these civilian areas, which is why the forcible transfer had to be carried out. If the Honorable Chamber has no more questions, may I take my leave? No, I believe.
May it please the Honorable Bench. My name is Marzia Yazdan, and I appear as the second speaker for the Defense Counsel, and I will address count 3 of crimes against humanity and Article 7(1) subclause A of the Rome Statute, as well as the application of Article 28B throughout all counts. But if the Honorable Bench allows, can I address the issue of the non-international armed conflict first? So it's actually our position that the conflict that occurred here was classified as a non-international armed conflict, if I can explain this. So the prosecution invokes Article 7(1)(a, and if the bench allows me, I please read it out. So crimes against humanity, for the purpose of this statute, crimes against humanity means any of the following acts when committed as part of a widespread or systematic attack directed against any civilian population with the knowledge of murder. So we will be refuting both of these classifications, that there was a directed attack and that there was knowledge of the attack. Following that, Article 7, subclause 2, part A says that there needs to be a furtherance of a state or organizational policy to commit such an attack. And so they must prove, the burden on the prosecution, that there is a policy to attack civilians as such. But the evidence shows a bona fide non-international armed conflicts with the BLL, and the threshold from this comes from Prosecutor versus Dadish, which is cited in our memo, and if I may read out the definition. So the armed conflict exists when there is a resort to armed force between states, or protracted armed violence between governmental authorities and organized armed groups, or between such groups within a state, and international humanitarian law applies from the initiation of such armed conflicts and extends beyond the cessation of hostilities. Now, if we examine BLL's armed violence that triggered this conflict and started this issue, we will see that on 15th November 2023, they bombed Rinder Bridge. Then on the 21st November, there's an assault on Lucan Airfield. Their first bombing kills 15 soldiers, then they kill 125 soldiers, and then there's the seizure of the provincial administrative complex by them. These were 3 offenses that initiated them. They were military attacks by an organized armed group, and the state's response is therefore governed by international humanitarian law, and in our submission, not Article 7. So it does not automatically equate with the specific intent that's required for crimes against humanity. And within international humanitarian law, the principle of distinction is paramount, because you have to understand the principle of proportionality is different. That will apply here, because it will be more lenient, because international humanitarian law acknowledges civilian casualties, however tragic, but they're an inherent part of warfare, particularly against an irregular adversary like the BLL, that directly embeds within the civilian population. And moreover, the prosecution's aggregate figure of 200,000 murders is misleading, because our government's own documents classify 70,000 of these individuals as persons of interest or security-aligned interests, and many others were caught in the crossfire of intense combat. And to categorize all of them as murder will be to erase the fundamental distinction that exists between members of an organized armed group and civilian that international international humanitarian law strives to protect, even in asymmetry. If the honorable bench is satisfied.
How do you explain the large number of civilian deaths?
Yes. Just a second.
And how the same was distinguished from the insurgents that you are referring to now?
So, as I stated again, the numbers are misleading. 70,000 are security threats, so they're not all murders. And other than that, the exact requirement against crimes against humanity is that each death has to be an attack directed against civilians, which the prosecution lacks, because this is a counterinsurgency measures that were taken in the context, as I've explained, of the 3 attacks that were done against the state, and then after which the state had to respond. Can I move forward
And
to?
what precautions were taken to reduce the deaths of civilians?
There were protection zones that were established during the displacement, and they were informed beforehand, before the evacuations. All of these, and you have to understand, in times of military necessity, certain measures are taken, and I will cite Prosecutor versus Haji Hasanovic, where it says that in assessing whether a commander took all necessary and reasonable measures, the chamber must consider the circumstances prevailing at the time, which may include the urgency of the situation, the resources available, and the operational constraints facing the commander. So the collateral, so this helps us understand that in the current situation, Nizam and the state had to take measures that did result in huge civilian casualties, but in the context was a military necessity. Can I move forward to my main counts? Okay, so I will start off with, I now turn to my first submission for count 3 of crimes against humanity of murder. For that, I will be relying on the judgment of Bagbo. My co-counsel were provided to the honorable bench. So the prosecution in this present case cannot, against Mohammed Nizam, cannot satisfy the requisite burden of, for count 3 of crimes against humanity, because they have to demonstrate two constitutive elements, which is part of Article 7 to subclause A. The first one is the existence of a state or organizational policy to attack a civilian population, and that the alleged attacks were committed pursuant to or in furtherance of that policy. So first, following the Bagbo ruling, the prosecution must prove that the attack was pursuant to or in furtherance of the state policy. And in our case, the evidence shows that Nizam's government was responding to a severe and escalating armed insurgency. The Moot problem details all the major attacks by the Biryani-affiliated groups. You will find them on paragraph 24, 29, and 30 to 33. These were not random attacks, but coordinated military-style operations using IEDs, machine guns, demonstrating organized armed challenge to the state. And Nizam's public statements characterized these events as an outright assault on the sovereignty of the state. And this followed the government's subsequent military campaigns, which are framed as counter-insurgency operations targeting these militants and armed Biryani separatists. Moving forward, the prosecution also fails to demonstrate that Nizam had the requisite intent for murder as crimes against humanity, specifically that he knowingly or intentionally contributed to the commission of these crimes. The evidence does not establish that he ordered, solicited, or induced the killing of civilians as a widespread attack. Now, his public address focuses on the accountability for agitators and those responsible for terrorism, which you will find in paragraph 34. The Bagbo decision acquitted Bagbo because the prosecution failed to link the accuser's speech to the ordering of the crimes. And similarly, in our case, the prosecution has mentioned Nizam's speeches, but similarly, they incite swift and unrelenting justice on, as you will find on paragraph 34, and they're directed at militants and not orders to murder. The tragic civilian deaths stem from the use of force in a military campaign. So if you apply the Bagbo standard, the evidence presented by the prosecution fails to meet the high threshold that is required to establish substantial grounds to believe that they were part of a widespread attack with state policy. Moving on to the second count of the application of Article 28B. Yes, much obliged, Your Honor.
All these military operations, instead of a judicial process, what do you think would be the reason of not adopting a judicial process but the military operations instead?
The escalation of the issue demanded such action to be required after major civilian casualties and bombing state infrastructure. This is the measures that the state decided that it had to take. Considering they were armed, there was in military intelligence of weapon stockpiles found. So from this, we can infer that Nizam had to act accordingly. I will be moving on to superior responsibility under Article 28B. So today, the prosecution asks you to confirm charges against a civilian prime minister under Article 28B of the Roman Statute. They claim that he is responsible for the terrible events in Mara, but to succeed, they have to meet one of the highest legal thresholds in international criminal law, and a threshold that has been made even stricter by the case of Prosecutor versus Bemba, which my co-counsel will provide. So, it's important to understand the effective control test that has been established pursuant to Article 28B. It does not criminalize being in charge when crimes happen. It criminalizes a specific failure when a civilian superior with effective control over subordinates fails to take necessary and reasonable measures within their material ability to prevent or punish these crimes. So, which was further established by Blaskik Appeals Chamber, which my co-counsel will provide. If I may quote from this case, a superior's criminal responsibility is not premised on his or her formal rank, but rather the material ability to prevent or punish criminal conduct. So the possession of power is not a prerequisite for command responsibility, nor does it necessarily signify the possession of the de facto effective control. So in other words, his title alone as prime minister is not enough. They have to prove that he actually had in practice.
Counsel, are both the cases that you're citing, both these cases relate to civilian responsibility
Yes,
or
Your Honor.
command responsibility, which would apply in the case of a military personnel or official?
So the case of Prosecutor versus Bemba refers to command responsibility, and their civilian responsibility is referred to in Blaskik, the quote that I will mention. But ICC has inferred the interpretation of Article 28B from these cases in multiple jurisprudence.
Or specifically attributing civilian superior responsibility.
Yes. So basically, these cases heighten the threshold for 28B, and they increase it even further for civilian superiors, which I will be establishing right now. So Under Bemba, it dealt with a military commander, and the core principle applies to all superior responsibility, and they make the prosecution's task very difficult because they emphasize on material ability, and the Bemba requires concrete specificity, not abstract speculation. So the prosecution must prove that he had effective control, material ability, specifically exactly what he should have done in each instance. Now, moving on, this standard is even stricter in civilian leaders. This is the fatal flaw in the prosecution's case. They treat him as a military commander. Civilian leaders do not have the same tools of control. They do not have a direct chain of command to every battalion. They don't issue daily tactical orders. Their power is political, diffuse, and it's mediated through layers of government. And I will be
established from the fact that he lacked this authority.
I'm sorry, could you
Yes.
repeat?
How would you establish from the facts
Yes.
that the Prime Minister Nizam lacked command over his forces or lacked control over his forces?
So Nizam received military intelligence, and based on that, he gave policy decisions. So the information that he was receiving, for example, on paragraph 40 of the Moot problem, was that there's aerial surveillance which shows armed separatists. The soldiers opened fire after they received intel. Drones are showing armed Birani snipers, and so from all of this, based on this evidence, he is issuing his orders. He does not know the exact specificities of what's going on the ground. He had
That's not really the test that you're arguing. You're arguing that he didn't have command over his forces. So how do these facts establish your argument that perhaps Prime Minister Nizam lacked authority or lacked command over his forces?
Much obliged, Your Honor. I don't think we are making that argument that he lacked authority. What we are establishing is under Article 28B, the standard, the threshold is very high for having the concrete knowledge.
And I'm asking you to establish how that standard was not met.
Right. So he received reports of operations against training camps and weapon stockpiles and legitimate military targets. He had no reports clearly indicating what exactly his forces were engaged in. And a leader is entitled to rely on military intelligence during an active conflict. To hold otherwise would create a strict liability for a civilian leader during war, which is precisely what Article 28 and Bemba guard against. Moving forward.
Has there ever been a conviction on against a civilian superior under Article 28 by the ICC?
Recently,
You just gave me two cases, so
both
one of
of
these-
those cases actually resulted in acquittals. So there was a conviction,
Yes.
and then in appeals, that is why we've cited them in our case. And both in these appeals, for example, in Bemba, they said that all measures it did not properly account for his material ability as a remote commander. And for Blaskik also, they said that there was insufficient proof of his effective control over his subordinate units. So we submit that his role was political, strategic, and not operational. His speeches that the prosecution has cited set a political tone, political rhetoric, but there is no evidence that he personally authorized those specific airstrikes, was in real-time communication with the field commanders, and had the practical ability to stop the bombardment once it had been launched. Should I move towards the pairs if the Honorable Bench has no more questions?
I think we'll review your pairs from the memorial. Thank you.
Okay, thank you.
Do we have rebuttals? The first point that you should be arguing on is jurisdiction.
I stand before this honorable chamber to advance rebuttals for defense counsel's assertion, and we humbly submit that the defense has failed to establish sufficient grounds to absolve Muhammad Nizam's responsibility and crimes against humanity. Your Honor, touching the first question of jurisdiction, this court has explicit jurisdiction under Article 7(1) of the Rome Statute. When it comes to the assertion by the opponent counsel of non-international armed conflict, Your Honor, the present case deals with crimes against humanity, bringing it entirely within the ambit of Article 7(1) of Rome.
I'm sorry, we're not supposed to interrupt during a rebuttal, but you haven't really made any elaborate point on jurisdiction, and you've jumped to the non-international armed conflict aspect. So on jurisdiction, how does this tribunal have jurisdiction?
Much obliged, Your Honor. The opponent counsel raised the assertion before this honorable chamber that since the conflict was non-international, so this court does not have jurisdiction
No,
for that.
Their argument was that perhaps there has been no ratification of the Rome Statute. Therefore, we do not have jurisdiction.
Much obliged, Your Honor. There has been ratification of the Rome Statute because if Your Honors could bring your kind attention towards the procedural portion of the moot case, it explicitly entails all the conventions that the state is party to, making it, bringing it entirely within the ambit of Article 7 and that of Rome Statute. If Your Honors is satisfied, may the counsel move towards the next rebuttal.
What's your point, sir? Can you please summarize it for us?
Your
On
Honors, if
jurisdiction.
you could bring your attention towards the procedural evidence
Yes.
portion of the case.
What does it say?
mentions certain conventions and treaties
And
which
what does it
both
say?
the states are parties to. And
Okay.
given the fact that these both states are parties to these international treaties and Rome Statute at large, so this brings it entirely within the ambit of this court's jurisdiction under Article 7(1) of Rome Statute. And the crimes that were committed against Birani civilians were crimes against humanity, which are explicitly enshrined under Article 7(1). If Your Honors does not have any further question, may the counsel proceed towards the next rebuttal. Your Honor, the defense also raised the point on ethnicity, whereas ethnicity is not to be looked upon in isolation. It has to be looked in conjunction with political identity, which has been clearly expressly mentioned in fact number 37 of the case, that their political identity became a problem. They were designated as a threat to the state integrity. So political identity is no ground to subject a civilian population to widespread attacks. Moving ahead, they also raised the question of military necessity. However, Your Honor, presence of 19 militants or 20 militants in different series of attacks does not impose a military necessity situation, whereas the casualties that resulted as a result of those attacks were far large in scale and intensity. Your Honor, the opponent counsel have also tried to mislead the court by bringing assertions like funding, whereas the court at hand is dealing with 3 counts pertaining to genocide, pertaining to crimes against humanity, and pertaining to the civilian responsibility on Muhammad Nizam. In addition to that, Your Honor, the defense also touched the question of burden of proof. Whereas the Rome Statute, Article 61 trial stage, requires only establishment of reasonable sufficient evidence, whereas in the present case, given the overwhelming factual metrics, the evidence is beyond reasonable doubt. If you could look at the initial portion of the moot case. With regards to the question of proportionality, the defense mentioned that there can be leniency. However, we also provided you with another key precedent where it has been clearly mentioned that there is no parameter of leniency when it concerns the question of proportionality, and it has to be met adequately. Your Honor, the numbers, the opponent counsel also stated that the figures are misleading. That is a complete absurd assertion, Your Honor, because it has been explicitly mentioned in the initial portion of the case at hand that the facts are agreed, and any reversion from that is merely misleading this honorable chamber. Therefore, Your Honor, on the grounds aforementioned, we humbly submit before this honorable chamber that the defense has failed to establish sufficient grounds to absolve Muhammad Nizam of his criminal liability, and that enforced displacement and crimes against humanity happened towards Birani civilians under the principle of UB Lex Remedium, which states that where there is a right, there is a remedy. If Your Honors does not have any further question, may the counsel leave the floor.
I have a question, same question, jurisdiction.
Your Honor.
I am looking at paragraph 60 of the facts. It says that the Prime Minister appeared pursuant to the warrants voluntarily.
Much
Paragraph
obliged.
3 of the instructions do not say that the Rome Statute has been ratified by Ashkar.
Your Honor, the paragraph number 60 is irrelevant in the case
Okay.
at hand. We are referring to Article 7(1) of the Rome
No,
Statute.
where in the facts? How do you establish from the facts that the Rome Statute
If
has
you
been
could grant
ratified
me a
by
second
Ashkar?
to bring my attention towards
Sure.
paragraph number 61.
You can also take a look at page 3.
Your Honor, there is no paragraph number 61 because after paragraph number 60, the moot problem is ending and
No, I
then it
said 60.
details the 3 counts that
I said 60, 60.
60.
Yes.
And what is your assertion?
That the Prime Minister appeared voluntarily pursuant to the summons.
Your Honors, he appeared voluntarily. That is irrelevant at hand because he has to appear.
Okay, so at
He
page
is
3
the
of the
accused.
instructions, page 3 of the instructions, it lists 1, 2, 3, 4, 5, 6 conventions that have been ratified by Ashkar, and Rome Statute is not one of them. So how would you say that the ICC chamber has jurisdiction?
Your Honors, because the crimes committed were crimes
No, it
against
doesn't
humanity
work.
under
International
international
law. I'm sorry,
law.
Counsel, but international law doesn't work that way. If a state says that doing something is a crime, they can't pull out citizens of B state and prosecute them in A state just because A state says that it's a crime, until and unless B states ratifies a convention between these two states. So for international law to be applicable, unless it's customary international law, a treaty has to be adopted by a state. In this case, where does it say that Ashkar ratified the Rome Statute? Does it or does it not? If it doesn't say so, be honest, just say it doesn't say so.
Much obliged, Your Honor. However, the Rome Statute is not to be looked upon in isolation, and these all treaties have to be looked upon, which these states are. It is
I'll rephrase
assumed
my
that
question.
these states are
I'll
parties.
rephrase my question. Does it say anywhere in the moot problem that Ashkar ratified the Rome Statute? Yes
Your
or no?
Honor, I do not have adequate information for that point. However, the genocide sustains under Article 1948 on crimes of prevention of genocide, so that brings it within the ambit of jurisdiction. And we believe that we have firmly established the jurisdiction, given the crimes were crimes against humanity.
Well, if you were to prosecute under the 1948 Genocide Convention, then you ought to file the case in the International Court of Justice. You do realize that, not the ICC. And back in 1971, Pakistan filed certain proceedings against India under the Genocide Convention before the International Court of Justice. Those proceedings were later withdrawn. But under the 1948 Genocide Convention, you can't sue individuals. You can't prosecute individuals. You can prosecute states.
Much
But over
obliged,
here-
Your Honor. Much obliged, Your Honor. If Your Honor
I'm just trying to
could
see how
continue,
you're
could
trying to spin this
continue.
around, because you can simply say that the moot problem doesn't
Your Honor,
specify.
the moot problem at large does not deal with the question of jurisdiction. It was merely a sub-argument advanced by the opponent counsel, whereas the 3 issues deal with crimes against humanity, civilian superior responsibility, and enforced displacement, which I believe have been firmly established by our prosecution.
But
And
you could have just said that in the beginning. But thank you.
thank you, Your Honor. If Your Honor does not have further question, may
I
the
have no
counsel
further
leave.
questions. Thank you.
If it pleases the Honorable Bench, may I begin? Honorable Bench, first of all, the main point of contention in this case has been jurisdiction. Even though prosecution would like to argue that in large, even though Ashkar has ratified other treaties but not Rome Statute, it still stands that then the ICC holds no jurisdiction, specifically because it has not ratified the Rome Statute, and all of these provisions where the count 1 is being charged under Article 6 and Article 7(1)(d) for count 2 and Article 28(b) for count 3, all of these articles are enshrined in the Rome Statute itself, and unless it has been ratified by Ashkar, the court holds no jurisdiction to hear this case and would have to retract this case and on its jurisdiction. The court may have subject matter jurisdiction, but it holds no territorial jurisdiction.
But counsel, there is a presumption that this court has jurisdiction because under paragraph 60, this court has issued summons. The pre-trial chamber, no? So the first question, whenever prosecution files a case in the pre-trial chamber, the court considers whether or not it has jurisdiction. So certainly the pre-trial chamber has considered the question of jurisdiction. and come to the conclusion that it has jurisdiction somehow. It's not there in the facts, but somehow it has come to that conclusion. So then why are we discussing this jurisdiction question at the time of confirmation of charges?
Much obliged, Your Honor. Even though the summons was a prima facie only under Article 58, Article 19 of the Rome Statute does give the defense side of the counsel the provision where they can contest jurisdiction in the first opportunity that there's been given to them, and based on that, defense presents the argument and the submission that jurisdiction here is invalid. May I proceed?
Yes.
The second point of contestation by the prosecution is that there was no military necessity. However, we argue that based on the fact file itself, on 15 November 2023, 21st November 2023, and 3rd November 2023, there were consecutive BLL attacks, and there was no response by the state. And after the BLL attack on 3rd December, which was what necessitated the military attack, the military response by the Ashkar state. And second of all, if we look at the case of Haji Hasanovic, it says, may I read from it? In assessing whether a commander took all necessary and reasonable measures, the chamber must consider the circumstances prevailing at the time, which may include the urgency of the situation. Based on this, the defense makes the argument that there was a military necessity, and there was a military necessity based on the insurgent attacks that were first made by the BLL, and the military necessity was in fact a retaliation to those BLL insurgent attacks. Third point is about where prosecution brings up that the number of people killed was uncontested. However, if we bring your attention to paragraph 37 of the fact file, where the number stated is 189,762 individuals of the Birani civilians. It also says that 70,000 of them were persons of interest, and they were security aligned threats, which shows substantial evidence that the state was doing everything in its power and everything necessary to take out the insurgents as it was within the resources given to them. If the court has no more questions, may I take my leave? Thank you.
So, all right, guys, moot court's over. Time for some feedback. We're told that the results would be announced by the organizers. We've turned in the score sheets, and they will be sharing the. Is that correct, Maham? Okay. So the organizers will be sharing the results with you as to who goes to the finals. Just some quick feedback from us. I think both teams had a good understanding of international criminal law and understanding of the basic concepts and understanding how the tribunal works. And obviously, if you have all my questions at least were directed towards basic concepts of international criminal law as opposed to specifically establishing the elements of crime and going into the charges in so much depth. So that was my criteria for judging both teams, and it was an absolute pleasure listening to both sides. I think the prosecution side had more fire in them because obviously they wanted a conviction from the International Criminal Court. So you could see that fire in them where they wanted the charges to be confirmed. Whereas the defense, I think the first speaker was very, very defty in raising a jurisdictional question and basically throwing them off guard. And they were really scrambling towards the end in answering the jurisdiction question. And that's exactly how defense is supposed to be. It's supposed to be defty, quick, and be very, very specific about why the charges should not be confirmed, or just throw some hurdle towards the bench in basically agreeing with the prosecution. So I did feel like this was a criminal case. So kudos to both sides for creating this atmosphere in the courtroom where it actually felt like this is a criminal case and not a civil or a commercial dispute. It did seem like there was a lot at stake here. So I appreciate the spirit and the energy coming from both sides. Just a few tips that I would like to give, starting with the prosecution, is that don't fight the judges, okay? If you don't know the answer to something, just say you don't know the answer to something. We know that you have stronger points to argue, and you've done your research on other points, and that's all you want to talk about. But then how you deal with the questions that you are not so sure of is also equally important, because that's how moot court competitions are designed. This is how real cases are designed. No one has it all, yeah, and no one has it all always. So there will always be times when there will be certain loopholes in the case. So while you guys were very elaborate, I felt that because you had consumed so much knowledge and you knew so much, you wanted to just tell the judges about everything that you had learned in the process. But I think what you missed out on perhaps during your arguments was that engaging with the bench is important, because they're the ones who will either agree with you or disagree with you. So bench satisfaction and bench engagement is core to any moot court competition, wherever you go. And so coming to the defense side, as I said, the way that you kind of took the floor and you said, okay, this is a fundamental question that the bench needs to consider. I'm pretty sure somewhere in the rules it says that the bench can't consider jurisdictional question, but the way you framed it was very, very defty. But I think, and I compared the memorials as well, these guys had better research. You could perhaps work on your legal research a bit more, work on cases, and maybe work on how you present your memorials. Because if you've gotten the memorial bit right, then you won't have any issues with the arguments and the oral advocacy stage. But if you haven't gotten your memorial right in the first place, then basically you'll be running in circles and like doing the whole thing again and again and again. So avoid that entire exercise and just get the memorial right. So that's my feedback for both sides, and all the best to both teams. I enjoyed being here. I hope you guys also enjoyed being here. I'd pass it on to my colleagues for their feedback.
Two things that I would like to point out once again, as my learned brother has already stated, how to engage with the bench. There was this disconnection. You speakers were like throwing out everything that you worked on, which is very appreciable, but the question is, the bench is there to satisfy itself whether to go this way or that way, not to just hear both the sides and then get confused what exactly the bench is supposed to do. So if there comes any queries to the bench, benches are there to seek assistance. We need assistance to this point to clarify our understanding, and then we act accordingly. That is what Leonard brother has already added, and very, very appreciable. Both the teams worked very well, and I really appreciate that.